how did you get Taylor to so graciously lend this song that's so pivotal to this movie?
I had nothing to do with it. I mean, this is all Blake. Like I said, Blake was involved in all aspects of this production, and she is also a marketing genius. You know, Ryan together are something else. But this was all Blake, and she knew that the song would work. She got Taylor to do it, and I had nothing to do with it. I was just so grateful that Taylor agreed.
Everyone, welcome back to the channel. Before we get into the legal discussion, let's start with a quick story connected to the film and the music used in it. Many people were curious about how such a major song became part of the movie. The director explained that the credit really goes to Blake Lively. According to him, she was involved in almost every part of the production and played a major role behind the scenes. He even described her as something of a marketing genius. Together with her husband Ryan Reynolds, she understands how to shape attention around a project. But in this specific situation, he said it was entirely Blake who believed the song would perfectly fit the film's emotional moment. She reached out to Taylor Swift and managed to secure permission for the song. The director said he personally had nothing to do with convincing Taylor and was simply grateful that she agreed to let the music be used because it became a key part of the movie's atmosphere. Now moving to the legal situation that has been attracting attention recently. A judge issued an order in a separate but high-profile legal dispute involving the television network Bravo, television personality Andy Cohen, and former reality TV cast member Leah McSweeney from the show The Real Housewives of New York City. The ruling focused on whether the case should be pushed into private arbitration rather than continuing in federal court. The judge ultimately rejected the attempt to force arbitration. This decision came after almost 2 years of litigation. During that time, the defendants had already filed multiple motions asking the court to dismiss the case. Some claims were removed, while others were allowed to continue. The process went through several legal rounds where parts of the complaint survived and others did not. After those attempts failed to completely shut down the case, the defendant suddenly argued that the dispute should move to arbitration under the terms of a contract. However, the judge was not convinced. His reasoning was simple. If a party truly believes arbitration is required, they must raise that issue at the very beginning of the case. Instead, the defendants had already spent a long period using the public court system to argue their position and ask the court to rule on complicated legal questions. Only after those arguments failed did they try to switch the process to private arbitration. The judge criticized this strategy strongly. He explained that a party cannot use the court when it benefits them and then try to escape the public process once things become inconvenient. In other words, arbitration cannot be used as a backup plan after litigation starts going badly. When a case begins, parties must choose one path, either arbitration or litigation in court. Trying both at different times undermines the legal process and wastes judicial resources. Another major issue in the ruling involved expectations of privacy. The court emphasized that federal cases operate under a strong presumption of public access. When people bring disputes into public court, especially high-profile disputes involving celebrities or media companies, they cannot expect the entire process to remain hidden. The judge noted that the public has the right to see court proceedings unless there is a very specific and serious reason to keep information sealed. General or vague requests for confidentiality are not enough. This reasoning closely resembles arguments the same judge has made in another widely discussed lawsuit involving Blake Lively. In that case, the actress filed a lawsuit, but also requested a very strict protective order that would place many documents under an attorney's eyes-only designation. That kind of restriction means the material cannot be seen by the public, and sometimes not even by the parties themselves without legal supervision. The judge has repeatedly pushed back against that approach. He has explained that temporary confidentiality during the discovery stage can sometimes be allowed, but once those materials become part of major legal motions, such as summary judgment filings, the expectation of privacy largely disappears. The judge's overall philosophy appears consistent across different cases. Whether the request comes from a plaintiff or a defendant does not matter much to him. What matters is whether the request attempts to use the court system while simultaneously hiding key information from public view. From his perspective, if someone chooses to seek justice in federal court, the process must remain transparent unless there are very strong reasons to seal specific details, such as personal contact information. He even commented that requests to seal documents must be extremely specific. Simply claiming that information is sensitive is not enough. Lawyers must clearly explain why each piece of information should remain confidential. Otherwise, the court will reject the request and the materials will become public. He also reminded the parties that if the case proceeds all the way to trial, most evidence will eventually be open to public anyway. The judge also addressed practical issues regarding evidence, such as audio recordings and video files. Since those materials cannot always be uploaded directly into the court's electronic filing system, the parties must provide physical copies to the court clerk when necessary. Once those items are officially unsealed, they become accessible to the public in accordance with court procedures. Another interesting development came when the parties involved in the case asked the court for a short extension of upcoming deadlines. Their request suggested that they were waiting for the judge's ruling on several major motions, including motions for summary judgment. Those decisions could significantly shape how the rest of the case proceeds. Because of that, they argued it would make sense to adjust the timeline slightly so their next filings could respond properly to the judge's conclusions. The judge granted only a small extension, just 1 week. Some observers interpreted that as a signal that his ruling may be coming soon. A longer delay might have suggested that the court needed much more time to prepare a decision. Instead, the short extension could mean the judge expects to issue his opinion relatively quickly. Of course, predicting exactly what the final decision will be is difficult. Some legal teams appear confident that many claims could be dismissed. Others believe parts of the case may survive and continue toward trial. Large, complicated disputes often involve hundreds of pages of legal arguments and evidence, so judges sometimes take several months to review everything carefully before issuing their rulings. There has also been speculation about the financial arrangements between celebrities and the law firms representing them. In some high-profile lawsuits, lawyers work on a contingency basis. That means they only receive payment if the client wins or reaches a financial settlement. In those situations, the firm typically receives a percentage of the recovery, sometimes around 1/3 of the total amount. Major law firms occasionally accept these arrangements when they believe a case has strong potential value. Even wealthy clients sometimes choose this option because large lawsuits can cost enormous amounts of money over time. Litigation involving celebrity reputations, entertainment contracts, or media companies can easily stretch for years and require extensive legal resources. By using contingency agreements, both the client and the law firm share the risk. If the case succeeds, both benefit. If it fails, the law firm may receive far less compensation for the time invested. All of these developments suggest that the upcoming court decisions could significantly shape the future of the dispute. The judge's previous rulings show a clear pattern. He expects parties who enter his courtroom to respect the public nature of the legal system and avoid tactics that waste the court's time. Whether the parties are major corporations, television personalities, or Hollywood actors, the same principles apply. Transparency in the judicial process remains a priority, and attempts to switch strategies mid-case, like moving suddenly to arbitration or sealing large portions of evidence, are unlikely to succeed without very strong justification.